SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. International child abduction sometimes happens when a child is caught in the crossfire of a messy breakup between parents. As divorce statistics rise and the global economy changes, families are increasingly torn apart. In cases where one parent takes a minor child abroad without following the proper procedures, the law has to step in to determine where the child rightfully belongs.
There are three separate requirements to apply the Hague Convention in a High Court matter. The one is that the child must have been wrongfully removed. That means that it must have been removed against the custody rights of one of the parents. The second thing is the child must have been removed from their country of habitual residence. And the third thing is that the left behind parent must have been exercising their rights at the time of the removal. Now, those are quite complicated. So basically what it means is that one parent must have been using their parental rights. They must have been visiting the child, had contact with the child, or the child may have been living with them even. And the other parent then removes the child despite those rights and tries to actually obstruct those rights by removing the child.
Children require an increased level of protection because they are vulnerable. They are the most vulnerable of society. And in this environment that the convention operates, children might fall victim of the conflict between the parents, where parents are not able to focus on the needs of the child and get consumed by the conflict. So the instruments such as the convention are there to help protect children.
Bonnie, sweetheart, it's time to wake up.
I don't wanna.
Shh. We have to be quiet. We don't want to wake up Daddy.
Why? Where's my daddy?
We are going on a trip. Just the two of us. Isn't that exciting?
But isn't Daddy coming?
No, sweetie. Not this time. It's just the two of us.
But...
Shh. We have to hurry. The taxi's outside.
By contracting into the Hague Convention on the civil aspects of international child abduction, South Africa has undertaken to other contracting countries that whenever a child is abducted to South Africa or from South Africa, steps will be taken to ensure first the prompt return of the child to the country of habitual residence, secondly to protect that child from further harm.
Sir, we just got word that their plane landed approximately an hour ago at OR Tambo.
I still can't believe she took her.
Maybe you should try calling her. I'll give you some privacy, but we'll be listening in on the other side.
Okay. You better answer this phone, Naomi, or so help me.
Hello?
Naomi? Who the hell do you think you are? Huh?
Oh, we just arrived home, safe and sound.
Shut up, Naomi. Just shut up.
I invite you over to come and stay in our home so that Ubongi can actually get to know her mother. And when you kidnap her in the middle of the night? What's wrong with you? You left us, remember? You wanted nothing to do with us. And now?
Yeah, I'm coming to again.
Is that my dad? Is that my dad?
I'm young notice to keep him back. Go help unpack the car, Bongile. Yes, I'm
You don't just get to change your mind. This is kidnapping, and it's a bloody crime. Listen to me. I will never let you keep her. Nomi?
The test for wrongful removal of retention is firstly that the child must have been with a particular parent in a country of where that child is habitually resident before the removal. And secondly, that removal must be wrongful. And thirdly, that removal must take place without the consent of the other parent.
What would happen in Hague Convention matters is if a mother brings the child to South Africa, most likely the mother will be the primary caregiver. And so it's extremely difficult for the mother to go back to the country where the child normally lived or where habitual residence was, because normally abducting mothers come back to South Africa because this is where their support structures and their family and everything. If they go back to the other country, they won't have visas or accommodation or employment.
Coming up, a father's real-life account of his child's abduction.
I heard that there was something wrong, that he couldn't talk really, and then the morning after, there was no more answer, and then I knew something was wrong.
South Africa has adopted the Hague Convention on the Civil Aspects of International Child Abduction, along with 83 other participating states. The legislation aims to protect children internationally from the harmful effects of their wrongful removal or retention from their home country. It provides for a fast-tracked legal process to ensure their prompt return to the state of their habitual residence.
The convention makes it possible to offer the children of our country better protection. Our constitution at section 28 really wants to protect the interests of children.
There are several objectives of the convention, but the main one is to restore children as quickly as possible to the position they were in before the abduction.
It's important that our country recognize international law and international conventions. As a constitutional state, it's quite clear that the rule of law is at the center of our constitutional democracy.
The Hague Convention and the Children's Act interact in a way that the convention is incorporated into the Children's Act. That makes it law in South Africa.
When Dr. Tuvin's marriage started to unravel, his 4-year-old son fell victim to international child abduction when his wife unlawfully removed him to Belgium.
The one night when I used to phone him, I would phone him every morning and every evening. I heard that there was something wrong, that he couldn't talk really, and then the morning after there was no more answer, and then I knew something was wrong. Through investigations that I made, it then transpired that my ex-wife had bought 2 plane tickets to Belgium, and that they eventually had left the airport and they were somewhere in Belgium, and it then transpired that she was localized at her parents' house with the minor child. Once I knew where my boy was, I then immediately proceeded to inform the South African Central Authority in Pretoria, headed by Advocate Siabi, and I told her what the problem was. And I must say, you know, we're always very reluctant to ask government departments for assistance because we always think they're very sluggish and we're just like a number. And I must say that I was very, very impressed. Not even 2 days after my request, I was invited to go there to bring all the relevant documentation, which is very important. And I would advise everybody that is involved in an acrimonious divorce to have a high index of suspicion that something might go wrong. And once it goes wrong, you're in a state, so you must have your paperwork in order. So if you have a custody order or a primary residence or shared responsibilities, to have that documentation available, so that the central authority can use that in their request or in the application to the state that now harbors the child to get the process going as soon as possible.
Dr. Turvin is now divorced and has been granted full parental care, but still allows his ex-wife to visit their son. In terms of the Hague Convention, a contracting state must set up a central authority, which has the duty of tracing the child and taking steps to secure the child's return. In South Africa, the Chief Family Advocate serves as the central authority. The Chief Family Advocate assists in both outgoing cases when a child has been wrongfully taken from South Africa or retained in a foreign country, as well as incoming cases when a child has been wrongfully brought to or retained in South Africa.
The Chief Family Advocate is designated as the central authority by legislation. That places the responsibility of the central authority that emanates out of the convention on the Chief Family Advocate.
It's important that we understand in the context of access to justice that our law and our rules of various divisions of the high courts make provision for the availability of judges every day of the week, even at night, if the matter has to be dealt with.
The process in the convention is supposed to be expedited and supposed to be very quick for the purpose of putting the child back in their original position. If you leave a child in one position, they adapt very quickly and they start settling. And if you then send them back to the country of habitual residence, you are traumatizing them a second time over.
Coming up, a complex court battle ensues to determine whether Bongi's mother is guilty of child abduction.
Mr. Matlala woke up to find his ex-wife had left the country in the middle of the night, taking their 7-year-old daughter with her.
Vusi flew from New York and made application to the South Gauteng High Court to secure the immediate return of his daughter to their home in the United States.
My lady, the parties involved were divorced in 2003, soon after the birth of their daughter, Bongile. Since then, Bongile has spent the vast majority of her life in the United States with her father, Mr. Matlala. But on the 14th of March 2011, Mr. Matlala generously flew his daughter's biological mother to New York so that mother and daughter could spend some time together.
Mr. Sole, who was granted primary care of the child in terms of the divorce order?
My lady, in terms of the divorce settlement agreed to by both parties and incorporated as part of the decree of divorce, the respondent agreed to allow Mr. Matlala full custody when she abandoned her family. If you turn to Annexure 3, you will find all the necessary documentation.
Thank you. Please proceed.
This year, the parties agreed that the Mrs. Matlala would stay with them for a month. But on the morning when the respondent was scheduled to fly back to South Africa, Mr. Matlala woke up to find his ex-wife had left the country in the middle of the night, taking their 7-year-old daughter with her. The respondent even went so far as to forge Mr. Matlala's signature in the documentation required to get the child out of the United States. And then, when Mr. Matlala finally managed to get hold of the respondent, who was already back in South Africa, she hung up on him, leaving my client with untold emotional distress. During the course of the proceedings, I will establish that the respondent is in contravention of the Hague Convention on Civil Aspects of International Child Abduction by unlawfully removing Bongile Matlala from her father's care in the United States and unlawfully retaining the minor child in South Africa without the applicant's consent. Therefore, I submit that Bongile Matlala should be sent back home to the United States with immediate effect.
The Children's Act, which came into operation during 2010, requires the consent of both parents. Both parents must consent in writing that the child can be taken outside the borders of the Republic of South Africa. To not obtain that consent before removing the child makes the removal wrongful automatically.
Milady, can anyone blame a mother for wanting to know her child? But with no money to fly all the way to America to visit her, how could she? My client acknowledges that she made a huge mistake by abandoning her motherly duties when her daughter was so young. But she herself was a young mother. It was only after spending time with her daughter in America that my client realized what she'd given up. My client has also instructed me that when she asked Bongi if she wanted to go back to New York, the child threatened to commit suicide. I submit that this alarming news only goes to support the fact that mother and child are clearly meant to be together. And I'll present evidence to show why this honourable court should order that the child be allowed to stay with the mother. In the matter of who has primary care, milady, I have documentary evidence proving that the settlement agreement entered into by the parties at the time of divorce was subsequently amended by order of the High Court. And in actual fact, milady, the respondent was granted sole care of the child.
Mr. Doit, are you referring to Annexure 16?
Yes, milady.
Have you examined this document closely, and are you satisfied with its authenticity?
Well, milady, there were many...
It's clearly been tampered with.
What? With the court's permission, I'll take instruction from my client.
Firstly, as we have seen in this case, that Nomi had falsified the decree of divorce by deleting the reference to the ex-husband and putting herself as the custodian parent. I think first thing that has happened is correctly the legal representative, that is Dutoy, has done the right thing by not convincing the court about the correctness of that falsehood, because all legal representatives are the officers of the court and they've got responsibility to the court. So thankfully Dutoy has not aligned himself with the criminal conduct of Nomi. When it comes to Nomi as to what has to be done, what she has done is actually a criminal offense. It can actually be taken as fraud, it can be taken as forgery, or even it can be regarded as contempt of court because it's trying to change what the court has decided without making a proper case before the court.
My client concedes that she did tamper with the document, milady, and that the court order with regard to parental care was never amended.
Falsifying evidence is a serious and criminal offense, Miss Matlala. We will deal with this matter once we are done with the present application, which by its very nature requires urgent resolution. Are you done, Mr. Doit?
Yes, milady.
Mr. Stolle?
My lady, I would like to comment on the respondent's alleged claims that Bongile had threatened to commit suicide when informed she might have to return to New York. The respondent falsified documentation to get her daughter out of the United States, and she has also falsified evidence brought before this court. Therefore, I submit that all these so-called suicide threats are nothing more than just another one of Mrs. Matlala's falsifications.
I think I've heard enough. We'll take a 15-minute recess, and then I'll give my judgment.
Parents that have unlawfully removed or retained their children in another country have got a number of defenses that they can fall back on. The most popular of those defenses is known as the defense of grave risk of harm. The parent might have fled excessive forms of violence, but the court will require a very high standard of proof that there was grave risk of harm.
The court will assess very closely the possibilities of psychological harm to a minor child based on, one, the relationship between the parent and the child, the set of circumstances where the child is going to be brought up, the changing in the circumstances from one environment to the other environment, the needs of the child at a particular point in time, and the needs of the child to maintain connection with the family. The court will weigh up all those issues and make a determination as to whether the child will not be negatively affected emotionally and intellectually before the decision is made.
The minor child, Ubongi, who's the reason we're all here today, has lived most of her young life in America. Judging from the respondent's feeble attempt at fooling the court, by tampering with an official court order, not to mention the unlawful removal of her own child from the applicant's care in America, she's clearly not the responsible parent she purports to be. There's no evidence before this court that shows that Ubongi would be exposed to any harm, physically or otherwise, if she were to return to America. In light of all of this, I have come to the conclusion that it's in the best interest of the minor child that she be returned immediately back to her habitual residence in New York City with immediate effect. I will not tolerate the unlawful and reprehensible tampering of documentary evidence in my courtroom. There certainly will be consequences due to the forgery of the permission documents in America. Mr. Doyd, I'd like a word with you and your client in my chambers as soon as we're adjourned. Please.
The cases of parents being untruthful in order to get the court to condone the unlawful removal or retention of the child in another country are very minimal. Very often the parents have got a legitimate reason for removing the child, and normally it's allegations that there has been domestic violence or domestic abuse, or there has been financial abuse, or any other factor that would have made the relationship unbearable for the parent.
You must be good. You must behave.
Okay. That's all of it. Time to say goodbye, sweetie.
Hambe kahle mntanami.
Usale kahle mama.
I'm really sorry.
Okay, hop in.
Can I sit in front?
No, I sit there.
It is important for parents to move as quickly as possible to secure the return of the child back to their country of origin, because the unlawful removal may be abrupt. It may interrupt the normal scholastic life of the child. It may interrupt other activities of the child. It may create anxiety for the child because they do not know when next they're seeing the other parent. Parents must obtain relocation orders before they take the child out of the country after telling the court that the removal is in the best interest of the child.
When parents of minor children are divorced, the court makes an order setting out which parent has primary care of the children. If a parent who does not have primary care removes a minor child to another country or keeps the child there, that parent is guilty of the crime of international child abduction. In South Africa, the chief family advocate is the central authority and has the power to deal with all cases of international child abduction. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.